Hello, everyone. Can everyone hear me this time?
I can hear you, Karina.
Okay, awesome. Welcome, everyone, to our webinar. My name is Karina, and I'm working as a student intern at the Justice Programs Office here at American University. Before we get started, I'm going to go over how the webinar is going to work today. All of the attendees are currently muted, so if you do have a question for our panelists throughout the webinar, please submit it using the Q&A panel located on the right side of the webinar screen. On this panel, you'll be able to see a drop-down menu. Please send your messages directly to Ms. Zoe Root. We also have a chance at the end of the webinar to ask our presenters some of the questions that you guys have sent in. If you experience any technical difficulties during the webinar, feel free to send a message using the Q&A or chat function. There's also closed captioning available on this webinar. It can be found in the multimedia viewer below the Q&A panel. At the end of this webinar, a brief survey will appear on your screen. We would appreciate it if you could fill this out, as it helps us improve our future webinars. And as a final note, this webinar is being recorded and will be posted to the JPO YouTube channel and JPO website. I'm now going to turn it over to Zoe Root.
Thank you so much, Karina. Welcome, everyone, to MOSAICS' second quarterly webinar. I'm Zoe Root, the project director of the MOSAICS initiative, which is dedicated to providing training and technical assistance to court stakeholders on how to best identify and assist survivors of sex and labor trafficking who are facing criminal charges. For those of you who turned into our first webinar, you know that webinar was an overview of the MOSAICS initiative and the availability of our training and technical assistance. If you missed that webinar, we'll give you a snapshot of that information at the very end of the presentation today. Today's webinar is on an incredibly important topic. It's the very first of our topical webinars, and those of you who work in the anti-trafficking movement will not be surprised that today's topic is trauma. There is absolutely no way to talk about assisting human trafficking survivors without first establishing some baseline understanding of trauma. Being trauma responsive is not something that you ever truly accomplish. It's not an item that you can check off your to-do list and move on to the next thing. Rather, trauma responsivity is a value that underlies every aspect of the interactions you have with survivors of trauma. It takes constant work and effort. Being trauma responsive is important in any setting, but it's particularly important in the courtroom setting, as court has the potential to be extremely re-traumatizing for anyone who has experienced trauma before. Accordingly, there is no way for court stakeholders to hope to effectively assist survivors without first understanding what trauma is, where it comes from, what it looks like, and how the courtroom environment can exacerbate it. I could not think of two people more well-suited to present on this topic than Miriam Goodman and Charlotte Weber. Miriam Goodman is the program director of the Women's Prison Association Alternative to Incarceration program, Justice Home. Justice Home is a trauma-informed and gender-responsive alternative to incarceration program for women of all experiences. Justice Home specializes in working with survivors of trauma, specifically survivors of intimate partner violence and sex trafficking who are criminalized for their survival. Miriam has spent the past 10 years working with survivors of trauma and trafficking. She was formerly the Assistant Director of Anti-Trafficking and Trauma Initiatives at the Center for Court Innovation, where she designed programming for people arrested on prostitution charges as an alternative to jail. She also has years of experience providing local and national training to judges, lawyers, and clinicians on trauma and working with trafficking survivors. Charlotte Weber is a clinical care manager at a Philadelphia-based managed care organization. She previously served as the Women's Service Coordinator of the Center for Court Innovation's Hidden Victims Project, where she provided counseling and advocacy services to survivors of trauma and sex trafficking with criminal justice involvement. Charlotte has worked in criminal courts throughout New York City and has focused on engaging courts to improve survivor experiences. She has provided training to judges, lawyers, and service providers on working with survivors of trauma. Charlotte holds a bachelor's and a master's degree in social work from New York University. So before I hand the presentation over to Miriam and Charlotte, I'll show you our standard disclaimer informing you that our project is funded by the Office for Victims of Crime and that the opinions and findings expressed in this webinar are not necessarily endorsed by the Department of Justice. And here's our overview of what we will be discussing today on the webinar. So we'll be starting with Miriam giving us an overview of trauma, like I said, talking about what it is, where it comes from, and how it manifests. Then we'll be talking about how courts can inflict re-traumatization through the environment of the courtroom. And then Charlotte will discuss some practical trauma responsive practices courts can implement and some positive examples of change. So we really want to leave you here today with some concrete examples of steps you can take, either large or small, within your particular role that can improve trauma responsivity in your courtroom. And then we'll finish off with the opportunity to ask questions. As Karina mentioned, if you do have questions throughout the webinar, please send them directly to me via the chat function, and we'll address them at the end of the webinar. So with that, I will hand the controller over to Miriam, who will be talking about the overview of trauma.
Hi, thank you so much, Zoe, and for everybody at MOSAICS for inviting me to speak on this topic. I love talking about trauma, and even that's kind of a weird thing to say, but I feel like a lot of people in this work, you know, we see it and we breathe it, and we sometimes don't even understand what it is that we're seeing. So I think when we're talking about working with survivors, especially in a court setting, it's imperative. So as you can see, there's a picture of a tree and the reason for that is that I'm a very visual learner, personally. And for me, when I think about trauma, and we're going to define it and go into what it is, I think about it as a tree, that when you look at a tree, you see leaves and branches, but we don't get to see the roots. We don't get to see, except actually this tree has lots of roots on the outside, but generally speaking, they're under the ground. And I think that this is how we kind of experience people who have been through a lot of trauma or are going through current trauma, that we see behaviors, we see individual actions, we see one part of a person, and we don't always connect it back to, but where does it come from, right? What are the roots of someone's thoughts, feelings, actions, and behaviors? And so as we go through today's power presentation, I would encourage you to, if you take very little away, if you're kind of on your lunch break right now as we're doing this, to think about what are people's roots, right? Like, where does this all come from? And an amazing graduate of our program one day when I was talking to her about this said to me, took it a step further, and she was saying, you know, what the criminal legal system and often what providers do is we forget about the roots, and so the tree dies. And instead of, you know, caring for it, we just spray paint the leaves green, right? And the idea that we can sort of provide Band-Aid solutions to things if we don't continuously look at, like, where and what is this, where are things coming from? Okay. Trying to do the next slide. Sorry, one moment.
It's on the left-hand side, Miriam.
Left-hand side. I'm sorry, I'm not. Got it. Thank you. Wrong way. Please hold. I'm a social worker and not great at technology. Okay, so here we are, moving right along. So what is trauma? This is a definition that I've adapted from SAMHSA, defining trauma to include communities. And I think that that's a very essential component of when we're speaking about trauma and oppression, that it does happen to individuals, but it also happens within communities. And I think the big takeaway of when we're thinking about trauma is that it is an experience that to the core rocks a person or community's understanding of worth, and that they feel as though their lives are threatened. And so there's drama and there's trauma. And I love a woman that I worked with one day explained to me that she had been dramatized versus traumatized, right? And that drama is the bad things that happen to all of us, the frustrating things that happen throughout the day. But it was a way to distinguish what is truly traumatic to her versus what just kind of stuck, right, in the day. And when we think about trauma, unfortunately, it is often not a one-time experience. It's something that we experience chronically throughout our lives. And with that being said, even though I can't see any of you or anything of that, as we're talking about this topic, it can be really overwhelming and triggering because we're all humans in the world. And so if at any point you are triggered, please take care of yourselves, because that is a huge part of being a trauma-responsive worker or organization, is recognizing when you're triggered and when you need to care for yourself. So when we talk about trauma, we usually focus in on the interpersonal trauma. So, and this is a very simple visual to talk about an incredibly challenging topic, right? So it's not, none of these are an exhaustive list. But when we think about trauma, we often think about interpersonal trauma. And those are the things that somebody has intentionally done to somebody else. And we can do another webinar as to why someone might cause harm or hurt to somebody at another point. But if we think about the things that fall under the interpersonal rectangle, right, things like childhood sexual abuse, physical abuse, domestic violence, these are experiences where harm has been intentionally caused to another. And I keep saying intentional because if we think about what that might do to an individual's sense of worth, their ability to trust others, right, that it would have an impact if somebody who usually is someone you know in your life and is there to care for you, or and maybe even does sometimes to make it even more complicated, if they intentionally hurt you over and over again, as humans, what we tend to do is we need an answer to why. Why am I being hurt? And what we do is we turn inwards and we say it must be me. And so when we turn inwards and start blaming ourselves is when we have to try to cope with all of those feelings, which we're going to talk about in a few. The second rectangle is about systemic forms of trauma and oppression. So these are where systems can traumatize, right? Court systems, foster care, education, health, law enforcement. And the way that systems traumatize is not because of one person's intentional desire to hurt, but because of a system is not created in a way that allows for any of the gray, right? It's usually a very black and white system. If we take the court system, for example, you're either the victim or you're the victim, you're the defendant. You're innocent, you're guilty. There's not a lot of room for that gray. And I think a lot of the work that I know I do, and I'm sure many of you on this webinar do, all falls in that gray. But because a system is often not able to individualize, people get caught up. And it's where people don't, when they don't fit into those neat check boxes, that a system can sometimes or often fail to see the individual needs. And then there's the structural forms of trauma and oppression that exist in our world, right? Racism, poverty, sexism, homophobia, transphobia, all the isms in the world. And the reason for even separating out these three types of trauma and oppression is that, one, I think often when we're discussing trauma, systemic and structural forms of trauma and oppression are not discussed, and they all work together to sort of create the same message to that individual, which is that your voice doesn't matter and we don't care, right? And so again, this isn't to intentionally blame anybody, it's just sort of the way that this can all work. So for an example, let's say a young boy, he's 15 years old, a young man of color, goes to school, and he discloses to his school social worker that he had been sexually abused at home. The school social worker is mandated to call in child services, right? So child services get called, and somewhere on that form of child services, it lists why he was being removed from home that he had been sexually abused, but it's somewhere in the form. The root, right, of why he's being removed gets lost. And so when he gets put into a group home, because he's already 15 and he's more likely to be put in a group home, he starts acting out on socially acceptable ways for young men, which might be acting violently towards others, running away, being aggressive, whatever other socially approved ways that young men tend to act. And because if we don't connect those leaves and branches back to the roots, it looks like he's just being a real challenging kid, right? And nobody wants to work with him. So he gets passed from one group home to the other because the behavior is not getting connected back to the trauma, the roots, which are the sexual abuse. So let's say now he's 18 and he's about to age out anyway of foster care, and he's like, has a case of the F-it, and he leaves, and he goes, but he has to survive. So he steals something to eat. And now he gets arrested for shoplifting, and he's before a judge. And the research we know about bias and racism in our system, right, that judge is far more likely to send this tall, young, black man to jail than any other counterpart. And so he goes to jail for 10 days because it's a low-level misdemeanor, and he's released, and he's told he has to go talk to a social worker. And he's definitely not going to go talk to that social worker because throughout, and granted, please excuse the simplicity of this example, but the messages, right, are that he experienced this form of sexual violence. He reported it to a system that's there to help. That system has to then report it to another system, child welfare, that says they're there to help. But because the roots get lost, he gets completely misunderstood. And so now when he has to go to a court-mandated social worker for a program, he's very unlikely to be open, forthcoming, trusting, and rather than blame him for that, I think we need to understand the context of where he's coming from so that we can adjust how we would engage with him. So all of that to say, if you take nothing away from this webinar, to think about how the person that's sitting before you in whatever role you play is going through all of these things, has experienced all of these things in some form or fashion or combination. And so how that person is treating you or reacting to you in that moment might have nothing to do with who you are. It's what they have been through. So I encourage you to always remember those roots. Okay. So I think about I call them trauma reactions as opposed to symptoms, because to me it feels unfair to tell someone who's been through hell and back that you now have a sickness and here are the symptoms of it. To me, with how people react to a traumatic event or multiple traumatic events is nothing more than a reaction. It's the same as if we were in a room together right now and I asked any of you what would happen if you put your hand in a fire. Each and every one of you, I think, would tell me that your hand would burn. However, because that's the human reaction of putting your hands in a fire. Please don't do that. But the difference of the level of burn and how long it takes to heal is extremely individualized, but the reaction of burning is human. Just like everybody's going to react to traumatic experiences differently, it will manifest differently, but the reaction in and of itself makes sense in the context of that person's experience. And so when we think about how people react to trauma, again, using that tree analogy, we often only see the leaves and branches. So we see the person getting high. We see the person drinking. We see the person engaging in self-harming behaviors like cutting. But if we don't connect it back to those roots, it looks like an individualized behavior that it can't be understood. And what we often do is kind of shame and blame when people, sorry, I just saw it pop up on the computer. Please ignore that. Okay, so what we do is that we often shame and blame those reactions as opposed to understanding them as amazing human resiliency. And so one way that I often describe this, and I use a lot of metaphors and analogies because again, I think that this stuff otherwise is just too heavy and hard to digest, is years ago there was a movie that came out and I think it's called 127 Hours, 147 Hours, 127 Hours. I should know this. I've said this many times. But anyhow, it's based on a true story about this guy who goes hiking in the woods, and as he's hiking, a boulder falls on his arm, and he takes out a little dinky pocket knife, and he cuts off his own arm to survive. And this movie comes out, and people are like, oh, my God, I don't know if I could do that. What an amazing story of survival. And all I could think of, don't know why, is, well, what if we didn't know about the boulder? And the story was a guy goes in the woods and just cuts off his own arm. Our reaction is probably not going to be, wow, what a story of resiliency. Our reaction is going to be like, he's crazy. What's going on? He's not okay. And this is kind of what we do to trauma survivors all the time, is we forget the boulders, right? We forget that there is a reason for why someone is reacting that way. The challenge is that a lot of times in our own lives, for ourselves and those that we serve, we don't see those boulders. They're invisible. So imagine walking around with so many invisible boulders all the time that people are reacting to. And so I just encourage all of us as helpers, healers, providers to think of what are your own boulders, what are the things that you're going to react to, and also when you're working with someone that they have their own that they're reacting to. And just to keep in mind that just because you can't see what is triggering them doesn't mean that they are not being triggered. Speaking of triggers are things that trigger a reaction, right? So they can be anything from any of the senses to time of year to time of day to location. And so the only reason that I bring this up is that when we think about the court setting, which we're going to get into, that is an extremely triggering place, because no matter what you tell somebody at court, everybody thinks they're going to go back to jail, even if they're doing incredibly well in whatever program they're in. And so people are at a heightened sense, right? And so they're going to react in a different way than when they are outside of court. The last thing I just want to say about trauma reactions is that if we don't grow as a community at large, remember the roots of trauma and oppression and the role that they play in how someone is behaving, thinking, and acting, we often misdiagnose and mislabel survivors with severe forms of mental illness. I'm totally not saying that mental illness exists. We need to have bigger conversations about it. But I think that what happens is that survivors of complex chronic trauma, their leaves and branches get labeled, and so they're given a treatment that isn't actually meeting the roots, that isn't actually healing because the medication isn't right, and the kinds of treatment they're in might not be right because they're never addressing those root causes. The other thing about this is that when we're talking about people who are get involved or become involved in the criminal legal system, we know that there are much higher rates of Black and brown folks that get caught up in the system, right? And if we look at the ways that diagnosis and communities of color have that history, there's much higher rates of people being diagnosed with more severe mental illness solely based on race. So if we take that form of racism and combine it with the court setting, it can really impact a person's labels that are assigned to them. I also just encourage everyone to think when you get someone's case in whatever way that you do, if you see diagnoses like borderline personality disorder and bipolar disorder, to not disregard them, but to just maybe explore a little bit deeper. Does this person even agree with this diagnosis? When were they given this diagnosis? I know I've worked with people who their diagnoses came from when they were 10 and 11 years old, and now they're in their 20s, and we don't know if that's still accurate. And the challenge with this, too, just to harp on this for a little bit longer, is the labels that we give people through diagnosis mean something, just like the label of a charge means something to the outside world. So I worked with a woman who for years had been diagnosed with borderline personality disorder with explosive episodes that she always joked she thought sounded more like a stomach issue than a mental health diagnosis. And because of that, the court, she was trying to fight to get her daughter back. And the court was not giving her daughter back because she wasn't taking the medication that had been, mandated to her years ago, because she didn't like medication and her trauma history was wrapped up with forced medication in her past. And because of that diagnosis, the judge kept making a determination, no, you're not compliant, you will not get your child back. We worked to get her diagnosis changed to post-traumatic stress disorder, which was much more accurate of what she had been going through. And within 3 months, she got custody back of her daughter because it's a much more understandable diagnosis. People know, oh, you're not sick, you're going through something. I know this because I hear it about soldiers, right? We hear PTSD and all of a sudden there's a little bit less of a judgment. So I just say that to be mindful of the labels that people might come to you with. So really, this is just to highlight that trauma can impact people in a variety of ways, right? Through the biological component of trauma. I am no neuroscience, but if you would like to read a really good book about it, The Boy Who Was Raised as a Dog by Bruce Perry is an incredible book that really, really looks at the impact of trauma on the brain and development. But what I will say about trauma is that when your brain is on trauma, meaning when you're going through something or you are triggered, we go into what is called fight, flight, and freeze mode, right? And most of us have heard about fight and flight. But the freeze mode is the reaction that is extremely common for survivors, and it's also the reaction that we start blaming people and people start blaming themselves. So, for example, the freeze reaction being, in other terms, can be called dissociation. So there's like a separation of your mind from your body. If you ever watch an episode of Law and Order where they have a survivor of rape on the stand, you might hear the attorneys grilling her about, well, if this really happened, why can't you remember this person's face? Can you point them out? And she might not be able to. She might be able to tell you this water stain on the ceiling, but not the face because she dissociated, because she froze. And so I just want us to think about the freeze reaction as a real thing, because it's something that people start questioning themselves. Well, why didn't I yell louder? Why didn't I call the cops? Why didn't I do that? And we in turn start to be, well, why didn't you? And we never want to lead with that kind of language because it feels extraordinarily blaming to the person that we're working with. Okay, we're going to talk more about trust and attachments in a few. So again, super visual person, and this is a very simple slide of the idea. I used to work for a judge, and she asked me one day, like, all right, Miriam, you've convinced me that trauma is real, it's a thing, but then if this person has really gone through what you're telling me, why don't people just yell out for help? Why wouldn't someone be like, over here, help me, right? Which is a totally fair question if you don't know much about trauma, right? And so in thinking about that question, I sort of came up with this slide of that the hallmarks, the cornerstones of ongoing traumatic experiences are secrecy, shame, and silence, and they keep people quiet. So, right, secrecy, trauma is full of secrets by the perpetrator forcing their victim to remain silent and threaten to hurt them or others should they not stay silent, right? Or for the person who's tried to reach out to help but wasn't believed by a family member or authorities. Silence, right? We live in a world that really doesn't want to, well, it's beginning to change a little bit, but really doesn't like to hear from survivors of violence or sexual trauma, right? We lead with a disbelief rather than, oh my God, are you okay? How can I help? So it enforces silence. What we do see often, though, is shame. But the way that we tend to see shame is not somebody necessarily saying, oh, I'm so ashamed, I'm so embarrassed, but rather through anger. Because anger is a much more protective umbrella emotion than to be vulnerable and show shame, right? So this might come out, in one of the courts that I used to work at in New York City, they used to have to yell, not yell, but say the charge out loud. And so as soon as prostitution would come out, you would see the change in a person's body language, how they would react, and it usually became angry, right? Because we just made that person so vulnerable and we just shamed them by announcing this charge that holds a lot of people have a lot of opinions about it, right? And so people would get angry. And so I'd encourage you to think about when somebody is really angry before you. And if you are a program, for example, like the one I run where somebody is mandated to us by the court, and someone shows up and they are so pissed off and they're cursing us out and they don't want to be there, rather than taking it personally, to contextualize that it is so full of shame and all sorts of emotions to be told that you have to come to a program. Okay. So the same judge, once we got through that understanding, asked me, okay, fine, so now I get all of that, but why does this person then come before me again and again and again? And so the only thing I could really come up with were these three ovals. And what it's sort of showing is that often when someone's going through a traumatic moment, there's a point where they are both needing to survive and are vulnerable to further trauma, right? And I think it's important to highlight the survival and the vulnerability because there's autonomy. I'm not trying to take away people's own autonomy, but I think we have to recognize that sometimes people are in a position where survival creates vulnerability. For example, with working with a lot of women who have survived sexual exploitation, if somebody, let's say, runs away from home because they're being abused at home, they're on their own, they're out in the street, and there's a moment where they have to make a decision. They need to survive, right? And they meet a really handsome guy who promises them the world. And so they decide the only way that I'm going to survive right now is if I hook up with this guy because he can provide a place to stay and food and what have you. And that creates a vulnerability to further trauma if he turns out to be abusive or exploit him. And so I just think that it's important to pause and honor that people are making decisions based on survival, right? And not necessarily because they have a lot of choice in it. Because we love to talk about good decision-making and bad decision-making, but it's not that simple. It's really, really complicated. So court involvement can trigger a trauma response for all the reasons that we already said, right? The environment can be really triggering and overwhelming. Having to come to court and deal with the fact that you are even involved in the court system is really overwhelming. I know that, one thing that a lot of people have said to me over the years is that just coming through the doors and seeing an officer with a gun is extraordinarily triggering and overwhelming for a variety of reasons. And so one thing that we started doing is we will meet people outside of the courthouse and walk in with them so that if they have a reaction to seeing a gun, they have someone with them that they feel safe with so they can, feel grounded and calm. And so just thinking about, the small ways and the big ways that court is very triggering and overwhelming. Again, most people think that they're going to jail when they go to court. And that big dark cloud hanging over you is in and of itself extremely overwhelming and triggering. The other part about court being very overwhelming is that if somebody's been through a lot of trauma where their power and control and voice have been taken away from them, being in a setting where that same thing is happening is triggering in and of itself, which leads us to, leads us to this coming slide. But again, I think, a lot of times people ask me, well, should we just assume that everyone's a trauma survivor? And honestly, if we're working in a court system, my answer is probably, because the experience of being arrested and going through that process is traumatic and full of lots of other feelings, even if they've been through nothing else. And so, again, I think that this is an important moment to also say that it's not to say that because someone's been through hell and back that it's okay. It's to make the trauma responsiveness, what means you make excuses for people, that it's okay that they just did X, Y, and Z. It's not what I'm saying. All that we're trying to say is that if you can expand and understand the roots of somebody's behavior, it gives you a context and it increases your likelihood of having further compassion and creativity in how to engage with that person. So it's not to excuse people's behavior, it's to contextualize people's behavior. Okay. So how does this play out? I'm going to kind of go through these pretty quickly because I want to make sure I leave time for Charlotte. But how it might play out. So avoidance is a huge trauma reaction, right? Who wants to go to a place, a person, or a space that reminds them of something bad that happens? We all have avoidance of things. For me, it's a dentist, hate going. I always seem to have another appointment that day. And it's real, right? I'll schedule a very important meeting, even though I know in the back of my head that I have to go to the dentist, but this other meeting is more important. We see avoidance play out with survivors all the time, right? I'm on my way, I'm almost at court, but then I never show up, right? It's really hard to show up to a place that makes you feel not great. So one thing that we started to do is to talk to people about all this beforehand, and not to say you might experience some avoidance because of your trauma history, but hey, court's really hard and overwhelming, so let's talk the day before to make sure you're feeling okay to go. So the other area that we see this play out a lot, right, is in non-compliance, right, or challenges in continuing a mandate. So that might be because either it's really, really hard for someone to engage and trust people. It might be really overwhelming to receive the help that you ask for, which I know sounds counter to what we all might feel. But sometimes, first of all, asking for help is an extraordinarily challenging thing to do for all humans, especially if you have asked for help in your past and have been met with responses of violence and hurt, or just someone not doing their job. And so I think we need to be mindful of when we're engaging with somebody that, again, it is going to take time, and as it should, for them to develop a trust. We kind of have operated in this world, in the social service world, that we think if someone isn't spilling their guts out to us from day one, that somehow they're not being truthful. And I really, really think if we're going to become trauma responsive, we need to pause on that and applaud people taking their time to get to know someone before they let everything out and down. There's a vulnerability in spilling every single detail of your life that you've ever been through with a person you're just meeting. And in turn, as the providers, I think we really need to think about, okay, just because this person didn't tell me everything, or their stories changed quite, for after a period of time because the trust has increased, doesn't mean that they were intentionally trying to hurt you or harm you by lying from the beginning. It's because people need a minute to trust. This makes it really hard when we're social service providers, because sometimes we need people to trust us like yesterday so we can get moving but in our program. But I think we need to really think about who we're working with and the things that they're up against. Right. So a note about trust, right? Survivors of exploitation and trafficking have been extremely harmed by people. So it's going to take a while to trust others. It seems kind of obvious, but we forget it. I've often heard in social service settings things like, this client wants to dictate their own treatment plan as if it's a bad thing, when in fact that's a great thing. We should be working in collaboration with people, right? People have more buy-in. A doctor would never be upset that a patient is involved in their own treatment plan, and neither should we when we're working with folks. And I think that, I think all of those things. Okay. So how does coercive control play out in a courtroom? So the idea of coercive control is often used when we're talking about intimate partner violence, but we need to also think about how systems can be coercive. And I really want to be clear that I understand fully, because I've done this for the last 10 years as well, that people can go into providing court-based services with the absolute best of intentions, and still mandated services can be extremely coercive, right? So I want people to not take this personally. I want us to use this as a moment to think about how we can be more creative with people who are system involved. So how does it look? What is it? How does it play out? The idea that a person and a system of authority thinks that they know what's best for another individual, if we pause on that and we think about someone who's been exploited or someone who's been through intimate partner violence, there's a real mirroring effect going on, right? That experience of a person or system of power telling you what you need. And if you don't do what they say you need, there are real consequences, like going to jail or prison if you don't comply with a mandate. That experience is very similar for a survivor, right, where their exploiter or their perpetrator has said, if you don't do this, then this is what will happen, right? And that experience is something that a lot of people, it is something that a lot of people experience when having mandated services. Okay. Okay. So I think that when we talk about coercive control, again, it's not to make anyone feel bad about anything that they're doing, but where can you give back choice and voice? And Charlotte's going to talk more about that later. But I just realized I missed a slide, so hold on one second. So here's a definition of coercive control. And I think, again, the idea being that it's this experience of having sticks and carrots, of using the system in this punitive, punishing way, when we're also telling the person in the same breath that we're here to help. So the experience for a person who's in the system to hear, okay, great, you're not going to go to prison. We're going to let you do this alternative to incarceration program. But should you not do it exactly as we think you should, or should you not cooperate with us if you've made a plea agreement, there are real consequences. It's a really mixed message. And so, and people hear that, right? Like, how is someone going to trust that you're actually there to help if the same person who's saying that can also be the person that's responsible for putting them in jail? And so the ways that my current team and our program deal with this is we're extraordinarily transparent and upfront from the beginning. We don't pretend that people aren't mandated to the program. We give choice and voice wherever possible. People see everything that we've ever submit or write about them, so they have a say, so it's no secrets. And we also just let them vent and are there in hearing what they're saying and agreeing with them when it feels really overwhelming, when a system is bringing you down or isn't working in the way that you want it to work or need it to work. Okay. So what can the court do? I mean, I think one thing is to not have the expectation that a courtroom, even with the most amazing staff in that courtroom, is a safe place, because court is often never going to feel safe. So I think what we can do is try to make it as safe as possible and as least oppressive as possible, but we're never going to be absolute in it. Okay. So I'm going to turn this over to my colleague Charlotte, who's going to jump into more like what can courts actually do. And I really hope that from what you've taken away from this beginning part is, if you, again, nothing else, the tree, remember the roots, and that what we're seeing are leaves and branches, and that we need to be creative and also authentic in how we are creating mandated services for people, particularly survivors of trauma. So without further ado, I'm passing the baton over to Charlotte.
Thanks, Miriam. Hi, everyone. So now that we've gotten an overview of trauma and what trauma responses might look like in the court, I'll use the next section of the webinar to review how you can implement that knowledge in the courtroom. And the good news is that there's small and realistic changes that you can make, and they're still very impactful because they're so different from how we normally operate within a criminal courtroom. So first, if you're in a role where you're working directly with survivors, you always want to introduce yourself, explain your role clearly, and then give an overview of what is going to happen in this process. When I used to ask my clients, what does safety mean or what does safety look like to you, very often the answer was predictability and consistency. So being able to give someone an idea of what they can expect in an unfamiliar situation can help alleviate some of the anxiety. You can also ask questions like, what are you nervous about? Because it gives you the opportunity to address your client's fear right off the bat. So they're not sitting with that through your whole session or intake or throughout the court process. It may be something that's not likely to happen at all, in which case you can offer reassurance. And if their fear is something that might come up, then you can at least, talk with them about how you'll support them and help them navigate that situation. I also like that phrasing, saying, what are you nervous about? Because it implies that it's normal that you would be nervous in this situation. This is work that requires you to believe the person in front of you. So I can't tell you how many clients I've worked with whose stories were not believed either by family members or in previous experiences with social workers or lawyers or systems. And if ultimately our goal is to offer support and help someone get connected to services, we need to be able to make a connection, and you can't make a connection if you don't believe somebody's story. And then a note about offering help and services. Always remember that the survivor is the first and foremost expert on their own experiences and their own needs. So sometimes you might have someone in front of you and you feel like you have a really good idea of like what would help them or a program that would be a good fit for them. I worked with a lot of clients who had a history of drug-related charges, and so oftentimes the response from the court was, this person needs drug treatment. And most of the time that's not what my clients identified that they need for a variety of reasons. But ultimately, and Miriam had touched on this before, if you allow someone to identify what they need and what services will benefit them, they're much more likely to be engaged. The other reason that that's really important is that, like we said, powerlessness is sort of a defining characteristic of experiencing a trauma. So being able to offer someone a little bit of power back wherever you can is really important. Somebody who has a criminal court case isn't going to have a lot of power in that situation, but allowing someone to identify what help they need and if they need and want your help is one small way of giving that power back. All right, so in terms of the overall sort of court culture, ideally you want all of your court staff to be trained to treat survivors with respect. So that might look like training court officers to enforce court rules in a non-aggressive manner, or even using a different tone of voice. Let's say you have someone in court who is talking very loudly and it's become disruptive. The difference between a court officer shouting at someone and kicking them out of court, or just individually approaching that person and just kindly explaining, that they need to lower their voice and explaining why, so it doesn't seem arbitrary or they don't feel targeted, like, oh, people just need to be able to hear what's being said on the record. Those two approaches are likely to have a very different outcome. I think it goes without saying, defendants should be addressed with their preferred names and pronouns. So again, if you're in a role where you're working directly with survivors, asking for preferred name and pronouns should be part of your intake process. And if the court is misgendering your client because they don't know, you should correct them. Answer questions, even if it's not your job or even if it's not your client. In my experience, criminal courthouses are large, confusing, stressful places. And if you're able to just, walk someone into the right courtroom, or if you don't know the answer to their question, like get them to the information office, even if you weren't working with that person, that goes a long way. And then lastly here, language access. I have seen cases get held up for the entire day because we could not get an interpreter to stand on the case. That situation is frustrating for everybody involved, but it's most stressful for the client, particularly if there's a language barrier and they don't know what's going on. And like Miriam said before, like oftentimes the fear is, did I do something wrong? Is something wrong with my case? Am I going to jail? So two just thoughts about that. If you're seeing, let's say, a lot of Mandarin-speaking clients coming through your courtroom, can you get a Mandarin-speaking interpreter stationed in your courtroom all day? If that's not feasible, another option is maybe to print out like little pamphlets that give an overview of the court process and how this specific courtroom works and answer some general like court FAQs, just so they have some information while they're waiting for an interpreter. And a note here about your individual behavior. So you want to pay attention to downtime. Trauma survivors are really perceptive, and your clients will observe you to assess, is this person trustworthy? Is this somebody that it's safe for me to work with? So if your behaviors are one way while you're sort of on and like working and standing on the case, and then during a break in court you completely change, your clients will notice, and it will probably impact your rapport with them. Right. So like later today or this week or whenever you have time, I would invite you to think about what policies exist in the court where you work, and what do you think should be changed, or what do you think could be enforced differently? And I'll give two examples here because they came up very, very frequently in my work in the courts. The first one is having cell phones in court. So, you know, there's a reason that they're not permitted. You can't be talking loudly or have a loud ringer on. You know, you don't want it to be like distracting in the courtroom. On the other hand, imagine that you have someone who is in a chronic state of hyperarousal. So they're experiencing a great deal of anxiety, physiological symptoms of panic, racing thoughts, and it's difficult for them to sit and be present, let alone like in a courtroom for 6 hours. For that person, being able to play a game on their cell phone, and there are like specific games now that are like mindfulness apps that you can have on your phone, and games that are designed to help people manage symptoms of anxiety. So being able to use something like that on their phone could be a really powerful coping tool for that person. So with that sort of trauma lens, and can you allow somebody to use their phone in court, you know, if they're just using it quietly? Is that something that we can permit? If that absolutely can't be changed in the courtroom, what's a way that you can enforce that rule in a way that's less harmful for survivors? So maybe another option is allowing that person to just sit outside in the hall so they can be on their phone, and then when their case is called, their attorney can run out and grab them. The other example that came up often with my clients was sleeping in court. So, you know, generally it wasn't permitted. I think the sense is you need to be aware, you know, ready for your case and respectful in the courtroom. But again, imagine you may have somebody who had to work all night. They may have been working until 5 or 6 in the morning. And then they came straight to court. They might not have slept at all, and it could be physically impossible for that person to stay awake. And that's just one of like many, many scenarios that could be contributing to their behavior. But again, with that in mind, is it okay to just let somebody sleep in court? And again, if it's not, how do you enforce that differently? So you definitely don't want a court officer to shout at someone to wake them up, or slam their fist on the bench, or you know, physically grab someone or shake them awake. These are things I've seen happen in courts. But maybe have like the attorney go and just kind of gently tap on the bench next to them, or say their name to try to wake them up in the least like frightening way possible. And the ultimate kind of point here is that if you take a punitive approach, you're more likely to trigger a trauma response. If somebody feels threatened, we're more likely to push them out of their window of tolerance, which is the space where they're able to function their best and like think rationally and regulate their emotions. And we risk triggering a trauma response or fight or flight, You might have somebody leaving court or noncompliance down the road. And I'll share an example that relates to that. I had a colleague who was working with a client. She actually finished everything she needed to do, and she was in court to close out her case. But it was a very chaotic court day. There were like 3 court calendars combined into one room. And then there were some issues with her documentation from the program. So her case had been called twice and still hadn't been closed. So meanwhile, she was feeling increasingly anxious and frustrated, and she ended up running out of leaving court. My colleague, with very good intentions, ran after her, like, no, don't go. We're going to close your case. I don't want you to get a warrant. But keep in mind, this is somebody who is leaving because it is no longer tolerable or safe for them to be in that space, right? And now somebody is chasing them down the hallway. What ultimately happened was that a verbal altercation ensued with a staff member. A court officer got involved. It escalated into a physical altercation, and there were really serious consequences. It's a bit of a worst-case scenario example, but I share that to illustrate that if we have, and that was in no way, the staff member was not responsible for what happened, but if we have this background knowledge and understanding of trauma, we're able to modify our own behaviors and how we respond to our clients to reduce, the risk of pushing someone out of that window of tolerance and to reduce the risk of further harm. So Miriam touched on this as well, but just to kind of recap that, this is a change that ideally should be made right away in the court. Don't state charges or treatment information on the record. One of the reasons that Miriam touched on was that having a criminal charge, and some charges more than others, carry with them a lot of shame and stigma. And when we're working with survivors of trauma, we want to reduce shame. So out of respect for the person's dignity, just don't state the actual charge publicly on the record. The other really important reason is that you don't know who is in the courtroom. So somebody's exploiter could be in the courtroom. And if you are stating publicly that you're referring them to this particular program for services designed to help them get out of their trafficking situation, and the exploiter is hearing that, they're probably going to try to intervene and prevent that person from connecting with those services, right? And worse, there could be a real escalation of violence and danger for the survivor. So we talked about some of the trauma responses that might be factoring into noncompliance. So now that you have that knowledge and you can consider, what factors may be going on, how can the court respond differently? Try to state bench warrants if you can. Like, can you give someone 1 or 2 more opportunities to come back to court on their own before you issue a warrant? Or if somebody didn't show up to court, but they've been in touch with their lawyer or their social worker, and we know that they're doing well and connecting with services, can we just adjourn? Because ultimately our goal was for them to connect with those services. If somebody goes MIA, eventually you'll have to issue a warrant, but you want to make that like a last resort, because if somebody gets a warrant, then they get arrested, and then they get incarcerated. And now that's another really serious trauma that's further compounding the already complex trauma that they were dealing with. If somebody does come back after missing court, be positive and welcoming. I worked with an awesome judge who, anytime someone came back, she would always say, "I'm so glad you showed up. I'm really happy to see you. How are you? Let's figure out the next steps and move forward." And that was really powerful, because if I had a client who was nervous about coming back to court, who had a warrant, I was able to tell them, no, I know this judge. She's not going to be angry. She's going to be really glad you came back. And that goes a long way in helping reduce the fear of showing up and coming back to court. And then just one other thought about that, if somebody's like always missing court in the morning and coming in the afternoon, you can explore that with them and, ask what's making mornings hard. It could be avoidance. It could just be a simple logistical issue that they didn't think to ask for help with, because our clients are so used to having to rely on themselves. Or maybe another option is to schedule afternoon appearances if that works for the court, just to give them a better chance of making it there on time. And in terms of services, just a reminder to be flexible. So, you know, we may have come up with a treatment plan and everyone was on board, and then it turned out to not be a good fit, or client had a bad experience with the intake worker. You know, things happen, but you don't want to be rigid just because that was the first plan we came up with, when ultimately our goal is to connect somebody with services that are really going to help them, right, and address their needs. All right, so a couple of thoughts about making treatment plans. You always want to think through who needs to communicate before the court date in order for this to be a success. So let's say you have a client who is incarcerated and they're going to be referred to a residential treatment program and released at their next court date, and that's the plan. So let's assume you've already found the program and confirmed that they have beds available, and confirm that this person meets their eligibility requirements. Maybe you needed to facilitate a phone intake while they were in jail, or fill out some kind of form. Have you confirmed, does this program require insurance? Do they take your client's insurance? Does your client have Medicaid? Did it get shut off when they went into jail? And if that's the case, do you need to communicate with the jail to make sure your client goes through discharge planning so their benefits are reactivated? Do you need to communicate with the judge and make sure that this is the first case called on the calendar so that your client is actually released in time to make it to the program during their intake hours? There's a lot of moving pieces, and there's only so much that you can be in control of. But, you know, as much as you can plan and think these things through ahead of time, you have a better chance of setting your client up for success. I worked with a number of clients who were incarcerated and were either mandated or recommended by the court to go to drug treatment, and they were released straight from court, so they didn't go through discharge planning in jail. Their insurance had been cut off, so then we were limited to like the 2 public hospitals that would take somebody without insurance, and then their case would get called late, and they got released late, and by the time we got to the hospital, there were no beds. So you know, sometimes it was a last-minute plan that was the best we could do, but it's frustrating to see that happen and feel like your client didn't have a chance of actually connecting with the treatment program successfully. And then just a couple other thoughts about what resources do you want to have on hand to improve experiences for your clients or for survivors. Particularly if folks are incarcerated and they're being released, they probably won't have a phone. It might have been taken in evidence and they won't have a phone for, you know, they won't get it back for weeks or months. So can you get them access to a phone in your office to make a call, or can you help them get like a prepaid temporary phone in the meantime? And then how are they getting home, or how are they getting to the program? If you're giving them subway fare, do you need to also print out a map because they don't have a smartphone to figure out where they're going? Is it safe for them to take the subway? I worked with a lot of trans women who experienced harassment and assault in the subway, and that was not a safe means of transportation. So if I had asked, you know, a client to get to a program and gave them subway fare, that wasn't going to happen, right? It wasn't safe for them. You might want to consider having like warm clothes or change of clothes on hand in your office. I included that because I had a client, I will never forget, she was released from jail in February, and it was 5 degrees, and she was wearing sweatpants and a t-shirt. And all I had to give her was my own outerwear, which, you know, you can't do that every time. That's not sustainable. But the other thing it made me really think about is, how can I ask someone to make it to an appointment, let alone like take a chance on connecting with someone or trusting in these services and making this huge change, which is what we're asking people to do when they engage in services. How can I ask that of my client if she doesn't have her basic human needs met of having like warm clothing in the winter? And then one other resource that you could consider having on hand, thinking back to the example I gave about the cell phones in court. You might want to have like little mindfulness coloring books available for your clients, or at CCI, we used to give our clients these plastic gemstones that were like different colors and sparkly and smooth in some places and pointy in others. So it was a great, you could like pay attention to the sensation of that in your hand. It was a really good grounding tool. So just think about, you know, like what other resources can you have to help support your clients get through this process. So that's the end of some of those concrete suggestions. I hope that it's given you a lot of ideas about things you might want to implement in your courts or changes that you might want to make. We included some positive examples here because we wanted to show you like really tremendous work is being done in courts and by individual judges and defense attorneys and prosecutors and service providers, and it's really powerful to see those changes happening and see what an impact they have. Some of these I've touched on a little bit, but I kind of referenced this when I was talking about clients sleeping in court, but I did observe a court officer shout at someone in a very, very aggressive way to wake her up when she was asleep. And the judge just immediately called him up to the bench and told him that not to do that again, and explained why, like gave a little trauma background and just, you know, explained how he could wake somebody up in a more appropriate way. It was great because the judge really has the authority to you know, explain why a court officer can or can't behave in a certain way. She also did it like individually with him, so she wasn't shaming him either. And she addressed the behavior right away, so that never happened again. And he felt really bad and changed his behavior after that. So it was great. This is another one that I sort of touched on, but our judge would always say warrants, like 3 or 4 times, as many times as she could to give someone a chance to come back. And you know, if we had been in touch with the client, she didn't worry about them missing court. We would just adjourn. But she really understood that like the focus was on building trust and engaging the person, and that issuing a warrant could potentially harm that process and move us further away from our collective goal of supporting the survivor.
Hey, Charlotte, this is Miriam. Just to add to that example, I think with saying warrants is also like sometimes where somebody has been arrested, like for example in the Bronx of New York, is a really unsafe area for someone to go back to and can be really triggering and overwhelming. And so I know, you know, in the work we've done together, that judges have been much more understanding if coming to that area where court is not safe. And so working creatively in how to ensure that the person is compliant with whatever their court mandate is, but recognizing that getting there might actually not be a good idea or safe because that's where their exploiter knows they're going to be, or that's where they're known to a community. So another just point to add there.
Yeah, absolutely. I'm glad you said that. It's definitely, you know, something that you want to consider if people aren't coming, that there's real safety concerns. So I'll kind of skip over this because I talked about it before, but just a note that, you know, sometimes people will complete a case and then they might come back the next week with a new case, and our judge was great. In the same way, if somebody was coming back to clear a warrant, she didn't like lecture them. There wasn't a punitive response. You know, she would usually be like, I'm glad to see you. You know, I wish it wasn't here, but how are you? And, you know, let's take it from here, which the clients really, really appreciated and felt like better standing in front of her. Something else I've seen judges do, so I worked in a courtroom that specifically handled prostitution-related charges, but our judge, sometimes the client would have an assault charge or something else that at face value it didn't look like it was related to a possible trafficking situation. But she would allow those cases to be moved into that courtroom and seen together. If there was, you know, if the attorney suspected that there might be some connection, or just if we knew that person had another case that was related to a trafficking situation, just so we could be able to handle all of the cases in a sensitive and appropriate way. And that's the end of our examples, I wanted to give one more because I feel like I gave a lot of negative examples about court officers. I've worked with some amazingly tremendous court officers who were so kind and helpful and like held the whole court together. So I just want to like give a shout out, and I've seen really awesome work happen from people in really every court role, and it's really powerful to see that. So with that, I guess I'll turn it over to Zoe so that we have time to answer any questions you have.
Great. Thank you so much, Charlotte and Miriam, for that incredibly informative presentation. Everyone who has questions, please feel free to type them into the chat box, and I'll read them out as I receive them. I think as people are thinking of their questions, I'll take this time to go through a couple announcements about our training and technical assistance and some upcoming events to put on your calendars. So Charlotte, could you hand me back the controls? Great, thank you so much. Oops, wrong way. All right, so if you enjoyed this presentation and are interested in receiving some more intensive individualized training and technical assistance in your court, there's still slots available to apply for training and technical assistance through MOSAICS. Again, a little summary of our training and technical assistance. It's specifically for court stakeholders who are interested in learning how to better identify and respond to survivors of both sex and labor trafficking. Our training and technical assistance is highly individualized, so we spend a lot of time getting information about you, your court, the types of cases you're seeing, what responses you've already implemented before we come in and start making recommendations, because we recognize that the manifestations of human trafficking and the appropriate responses can be really unique to each court setting. And so we seek first to understand what is going on in your court before we make recommendations. Our training and technical assistance can be both remote or in person, depending on the intensity that seems appropriate and works best with the schedule of your court stakeholders. So if you're interested in applying for the training and technical assistance, it's 100% free and grant funded by the Office for Victims of Crime. And you can go click on the link that is appearing on your screen now. The applications are due by August 30th. It takes about 15 minutes to fill it out. It's really not too intensive. Once we receive your application, we'll set up a phone call to get a little more information from you, and recipients of the training and technical assistance will be notified by September 15th. And if you have any questions, you can email them to mosaics@american.edu. Some exciting announcements and upcoming events. Our partners at Project Trust are holding a really appropriate community call to as a follow-up to this webinar. So that's happening on August 20th at 2 p.m. And it's for anyone who works in the field of anti-trafficking or for an anti-trafficking organization to talk about successes and challenges in integrating trauma-informed policies into their work. So it will be a similar topic to this webinar, but it will be more of a discussion and opportunity to sort of talk about what works and what doesn't. If you're interested in registering for that community call, the link is on the screen right now. Project Trust is also currently recruiting survivors to be on their advisory board. So if you are or you know any survivors who are experienced in providing trainings and reviewing materials that are specific to trauma responsiveness on behalf of survivors of human trafficking, they would be a great candidate for this position, and they can find out more by going to the link that's on the screen. And finally, our next MOSAICS webinar, quarterly webinar, is going to be on November 12th at 2 o'clock. That will be presented by an amazing defense and prosecution team, Kate Mogilescu and Dahlia Racine, who will be talking about the scope of criminalization of trafficking beyond prostitution. So those are some exciting events that are coming up. I'll give folks a little more time to type in questions if they have any questions to ask of Miriam or Charlotte. In the meantime, if you know anyone who should have tuned into this webinar and didn't, the link to the recording of the webinar will be on the MOSAICS website, and I typed that into the chat earlier. All right, well, it looks like we don't have any questions. If any do come up in the future, please feel free to reach out at mosaics@american.edu. Thank you all so much for taking the time to tune in to our webinar. Please take the time to fill out the evaluation after you log off. It helps to inform all of the work we do and to improve future webinars. Thank you so much, and see you on our next webinar on November 12th. Bye, everyone.